Nearly 20 years ago, Europe introduced a regime for the protection of individuals' rights in their data. Since the regime has been in place, we've seen the development of the internet, smartphones, social media networks. The current regime is no longer fit for purpose, and we're now looking to replace it with a new, more robust personal data protection regime. In 2012, the first draft of the General Data Protection Regulation was published. This has now been an agreed form draft, which should come into effect in 2018. The difference between the old regime and the new regime is that it will have direct effect, meaning it will be one law across Europe, which should help to harmonize the situation. In essence, the core of the regime will not change. Personal data processed in Europe must still be processed fairly and lawfully for a specified purpose, not kept for longer than necessary, and not transferred outside of Europe unless adequate protection is given to the personal data. There are, however, other changes that will affect many clients. Any company that's compliant with the European regime at present may need to review its reporting and oversight obligations, as there are greater accountability issues in the new regime. For those offering goods and services to Europe that aren't compliant with the new regime, no matter where in the world they're based, they will need to ensure that they do become compliant. Failure to comply with the new regime may result in fines being issued of up to 4% of global turnover. Over the next 18 months, guidance will be published as to how the regime is going to be implemented. Companies need to be aware of the guidance and to take action as and when it's published to ensure that when the regime comes into effect, they are in full compliance with it.